Well, good afternoon now, everybody. Thank you for joining us for the August edition of the Real Property Law section, What's Up With Us monthly webinar. And you may recognize me. My name's Neil Kalin. I am one of the advisors on the RPLS Executive Committee, and normally I am joined by Michael Simpkin, but Michael is out of commission today, so we have him replaced by his predecessor, Ashley Hole. Hi, Ashley.
Hi, Neil. It's nice to be back.
Ashley is an originator of What's Up With Us, and I don't know, Michael and I guess, are a little more substantive. Ashley and I just would goof around for about an hour. So, so
We had
it's
fun.
going to
It
be a
was
different
great.
environment for you, Ashley.
Very entertaining times, Neil.
And you see another face up there. We're being joined by Stephen A. Sokol Esquire. I have a history with Steve because about 20 years ago, Steve was my boss. And so I'm kind of a little anxious today, doing something with my former boss. So hi, Steve, welcome.
Hello there. Welcome to everyone.
Thank you, Steve. Well, we're going to get started in just a second here. I figure out how to do things. Ha! Okay. So I am missing one of my monitors today, so I'm hoping I do this correctly. I'm going to try and, good. Change the slide. Here we go. So here's what we're going to be doing today. As a reminder, since the beginning of the year, What's Up With Us is eligible for 1 hour of self-study MCLE credit. You don't have to do anything. Just by being here, you get 1 hour of self-study MCLE credit, and that's good news for you. You will get a certificate no later than Monday when you get a copy of the slides from today's presentation. And we started something just 2 months ago, I think. We are rewarding those people who actually show up, people who sign up and actually show up. We are rewarding one of you every What's Up With Us with a gift card for 1 hour of MCLE in the real property section portion of the CLA library. Some of you may wonder, how do we pick a winner, right? Do we look for people that we know? No, that's not what we do. We pick a random number before we start the presentation today, and the person who has signed on with that number, or however that
Logged on in the
number.
order that we picked the number, yes.
Thank you, Ashley. I'm just going to rely on the two of you to do all the talking today. So the winner today is Bruce Boyd. So congratulations, Bruce. In addition to getting 1 hour of self-study MCLE credit for free, you also get an additional 1 hour. So enjoy your time in the CLA online library. We have some great cases that we're going to talk about today. A case about, can you get a prescriptive easement if the improvement that was built is a public nuisance? And that's Wang versus Paletta. We're going to talk about Applegate versus Carrington foreclosure, which addresses a relatively new law in the foreclosure process in California. We're going to do some kind of interview with Steve. We'll see how we're doing with time. And then we've got two great cases that are not necessarily real estate cases, but I thought might interest you because a lot of time these cases, maybe you look at the daily reports and you just kind of skim over things that don't seem important. But Thomas versus Corbin Restaurant is a really fascinating case. It does have real property implications. Ashley will talk about those implications. Steve will talk about his own take on this case, which is what happens if there is a spammed email and settlement money gets sent to a fraudster rather than the person who was entitled to receive the money under a settlement agreement. And a really interesting case, Getzel versus State Bar, which is, can an inactive licensee serve as an arbitrator or a mediator? And we talk about that. I'm going to talk about, there's a whole bunch of other things that might fall within this same general category. So a lot to talk about. There's a lot of upcoming activities for RPLS. So hopefully we'll have 4 minutes at the end of our program so you can see what's coming up with us, what's up with us, right? So let's start with Wang versus Paletta. And here we go. So great. You two ready?
Let's go.
Ready to go.
Let's go. All right. Terrific. So what happened here with Wang versus Paletta? Excuse me. Case decided recently in June of this year, end of June. You have Wang, who built a 290-foot retaining wall between his property and the neighboring property. Not like a little, 3-foot, 4-foot, maybe 5-foot retaining wall. The heights of this wall went up to 17 feet. It was built in the late 1990s. Properties or the neighboring property changed hands. The wall was built. There just used to be a barbed wire fence there. Wang probably believed that was the property line. 2013, the neighbor Paletta bought the property. 2018, 5 years later, obtained a survey and said, guess what? A lot of that wall is on your property. Paletta wasn't too thrilled with that, found out that the wall did not meet current building code requirements, went to the county issued a citation for the unpermitted work, and you're going to see a little bit later down in the summary, very expensive to take this wall down. Now, something that Michael would have loved if he was here, because he loves all this procedural stuff, not me. Paletta made a motion in limine to exclude evidence that there was prescriptive use of the area where the wall was on Paletta's property. The trial court granted the motion. So basically the trial court said, guess what, Wang? You can't bring in any evidence of prescriptive easement here. That's my understanding of a motion in limine. You're precluded from bringing that evidence. Guess what? Now you've got a problem. How are you going to establish ownership rights over that property where the wall went over the property line? Of course, Wang not too happy about that. The decision was appealed, and the trial court basically the appellate court upheld the trial court, basically saying, if you have a public nuisance, you cannot establish prescriptive right. So the appellate court basically affirmed the trial court's decision. Another argument that Wang raised was, well, maybe I have an equitable easement nonetheless, even if I do not have a prescriptive easement. And the appellate court said, well, in order to get an equitable easement, you have to be innocent. And we find it hard to believe that you, a successful attorney, you and your spouse, both successful attorneys, you did other improvements. Somehow your other improvements complied with legal requirements and permit requirements, but this 290-foot retaining wall did not. So we're finding you are not innocent. You're not eligible for an equitable easement. Ashley, why don't we start with you? Take it away. What do you think? Right decision, wrong decision, a problem? What's
I
up?
think it sounds right to me. I mean, this happens a lot where you have people who build walls thinking that they are on the property line because there's an existing retaining wall, existing tree line or something that has always been deemed to be the property boundaries and no surveys were ever done. So I think this comes up quite a bit where you have neighbor disputes over encroachments and things, for one. And then two, obviously, if you had no permits on the wall, then you're gonna have to take it down. The city's gonna make them do that. So obviously at the cost of $200,000 to $300,000 in this case, which is not insignificant. So yeah, I don't,
And finish up. I'm sorry to interrupt you.
no, go ahead.
I was just going to say, so let's say Wang decided to take it down, said, okay, I'll take it down. I'll spend the $300,000, I'll take it down, and then I'll build it back up exactly where it was, because I should have had, under prescriptive use, not only have I used this for 5 years, I've used this for basically 25 years, right? And let's say Wang's willing to spend the money to do it. Should they really be denied just because the property was built without a permit? And Steve, I think, has an opinion on that issue.
Well, I have one or two opinions. We'll see if my opinions correspond to each other. When you look at any explanation of what prescriptive easement consists of, the elements are that the use has to be open and notorious, continuous and uninterrupted, hostile to the true owner claim of right. In any explanation, it never has the sort of ghost fifth element, which apparently, as this case says, is that it cannot be a use that constitutes a public nuisance. In this case, the trial court and the Court of Appeal could have ended up with the same result. I mean, as Ashley says, government needs to be able to enforce the compliance with building codes and safety codes. They could have done the same thing by simply saying, well, the order that the county of, I think it was Napa County, that the county issued orders that the wall either be taken down or that it be that they obtain a retroactive permit and comply with all of the safety and regulatory restrictions. They could have done that and forced Wang to remove the wall after he and she had established their prescriptive easement. So what bothers me about it is, number one, it's sort of this phantom fifth element, and the idea I would prefer that the issue of easements remain an issue between the parties to the properties, not having government have a large hand in deciding whether there's an easement between these two private parties.
That's a really good
Ashley, you're
point,
sort of
Stephen.
nodding your head.
Yeah, no, I thought that was a really good point. I forgot that, yeah, I mean, going for just the elements for prescriptive easement, I mean, public nuisance is not listed there on the original elements. So that's a very good point.
Okay. So
The
for
court just
those
sort of
who
made it
want to
up.
take a look, so that's why we've got three, right? Because somebody's bound to think of something amongst the three of us. So for those who want to take a look at Wang versus Paletta, something we're not discussing today, but is at least touched upon sort of in the equitable easement argument, there is an unpublished portion of this opinion. And it's really a fascinating unpublished portion of the opinion. And when you look at that, I think you'll get a sense why maybe the court says the equitable easement argument failed. So I encourage all of you, take a look at that unpublished portion if this case interests you. If you want to know a little bit of dirt about what's going on in Northern California in the Napa area. Any closing comments, Steve or Ashley, before we move on? No, okay, looks like we're good then. All right. Here we go. So Applegate versus Carrington Foreclosure Services LLC. So what happened here? Well, you had a borrower, someone bought property, borrowed money. Guess what? Couldn't pay it all back. Property went into foreclosure. Notice of default was filed. Make some room here so I could actually see what I'm talking about. And then a notice of sale. And at the time of the notice of sale, how much was the unpaid balance of this loan? It was $2 million, right? So we're not talking about a one-bedroom condo in Fresno. I don't remember exactly where this is. Maybe one of my two colleagues remember exactly where this is. The property went to foreclosure, and what seemed like to me unusual, maybe the two of you could tell us how unusual or not it really is, but the beneficiary bid was only $100, right? I just assumed beneficiaries always do a full credit bid for the amount that's owed. And I don't know if this beneficiary was, out of state where they just do the minimum amount. I have no idea, but that was really, that was crazy, right? $100 for a property with a $2 million balance on it. But afterwards, the beneficiary instructed the trustee, oops, we messed up. We requested you pull the foreclosure. Do not make this foreclosure final. Well, a few years ago, California passed a law that allows a prospective owner occupant to bid on property after the foreclosure sale. And it's sort of a two-step process. They have to give a notice of the bid, and then they actually have to provide their bid. And Applegate was trying to take advantage of that, but you have to comply with the law, and the law says you have to complete a declaration that says you are a prospective owner occupant, and there's a bunch of information that you have to complete, and it's not really that complicated, but you've got to do what the law says. Guess what? Applegate did not do that. Applegate tried again, tried 2 times, and still did not provide the information that the statute tells you is necessary if you're going to take advantage of this process. So guess what? Applegate did not get the property. Applegate said, well, wait a minute, I should have been allowed. You are not allowed, trustee, you're not allowed to basically rescind the sale, because what happened later? What happened later is the beneficiary made, a full credit bid, which probably should have been done in the first place. Okay. Applegate sued. Trustee brought a motion for summary judgment. The trial court said, we're going to grant that for 2 reasons. First of all, there was no private right of action under this relatively recent California law. 2, the sale was never finalized. It could not be finalized until that time period had expired for a prospective owner occupant to make a bid on the property. And 3, guess what, Applegate? You just didn't provide the correct documentation. The decision was appealed, and basically, you see there on the screen, what did the court say? Once the sale is postponed, all bids are automatically canceled. So there never really was something for which there could have been the opportunity to bid on. And of course, the statute requires strict compliance. Steve, why don't we start with you? What are your thoughts about this?
Well, there's what this case stands for, and then there's what this case produces that it doesn't necessarily stand for, which I would call something like, what's lurking in the weeds, not just snakes. Because the odd fact of this case is that statute, 2924M, says basically that a trustee sale is not complete when the hammer goes down at the time of the trustee sale, if it happens to be 1 to 4 family residential property, which is majority of foreclosed properties. So for 1 to 4 family residential properties, it gives tenants of the property and others who might bid to live in the property an opportunity to buy after the foreclosure sale is conducted, but before it becomes final. So the legislature thought they were saying, well, that means more homes will be owner occupied instead of going back to lenders or to capitalists. So that's fine. But what it means is, at the time of the sale, in this particular case, the lender, for whatever reason, bid $100. And the lender apparently came to their senses and instructed the foreclosure trustee to cancel that particular sale, postpone it, and that means they'll set a different sale date, which they did. Had they not done that, if they had left their $100 bid in place, and if Mr. Applegate had come in and bid more than $100 and had sent the right document, a declaration or affidavit along with his bid, he would have presumably had the legal right to purchase the property. The lender would have only got $100 instead of the $2 million balance on their loan. So what the working in the woods, in the weeds, is the fact that when you normally look at a trustee sale, when the hammer goes down, the trustee sale is finished. And whoever was the successful bidder at that time gets the property, assuming they pay what they offered on their bid. In this one, this could easily happen again, that some lender doesn't bid the full amount that they're owed, and someone comes along and, unlike Mr. Applegate here, they said, oh, maybe perhaps I should read the code section or comply with it. And somebody advising the lender might consider taking a better look at what the law is, or bidding the full amount that's due on your loan. That's the big takeaway to me is watch out, for not complying.
So Ashley, before you go, Steve, I think one of the things you're saying is that the attorney who was advising the beneficiary got lucky.
Yes, the lender, and yes, and the attorney can still go out, for drinks and be happy and go dancing and whatever it is, because they're not shorted $2 million this way.
Right. Yes. Okay, Ashley, what's your input?
Yeah, I mean, I don't deal with foreclosure in my practice, but I do know how specifically meticulous the courts are about following the statute, having all the things for the trustee sale. So certainly the buyer, Applegate, he should have, consulted with an attorney to submit the correct paperwork to be, if his bid was rejected the first time, and it didn't go through, then he probably should have hired an attorney to say, hey, why didn't this go through? What did I need to do? And then they would have submit the right forms. But yeah, it's very strict compliance with the statute, unfortunately, here.
And when you talk about that, I'm thinking, some people just you ought to be able to take the hint, right? When your first bid is rejected for non-compliance, how can you make that same mistake,
Right.
a second time around? So, sorry,
This,
Applegate, under this set of circumstances, my sympathies are not with you in this case. So, well, thank you both. Before we go on to our brief interview with Steve, I forgot to mention this earlier, but there is a Q&A tab. So if somebody has a question or a point or an issue they want to bring to our attention, please put them in the Q&A tab. And going back to our previous case, Wang versus Paletta, Bernard makes a comment. And so we're talking about the Wang versus Paletta, the retaining wall case. He goes, isn't this just like the case from last month, or it's either last month or the month before that, where the court ruled a roadway to a cannabis farm does not create an easement because cannabis use is illegal on a federal level. Okay. And my recollection of that case, and I'm sorry I don't have the name of that case off the top of my head, was there was an easement, and the issue is whether the easement allowed for basically the transportation of cannabis over the easement. So there was an easement. They were not seeking a prescriptive easement. There actually was an easement. And my recollection of that case is the court said, guess what? That's an illegal use of that property. So you cannot, that is basically outside the scope of the easement. The easement does not allow for an illegal use of that roadway that went to and from the cannabis farm. So thank you, Bernard. Glad somebody's paying attention to what we talk about here. I just think that's the distinction. And we have another question here, and we're going back to the fence case. Why was the fence case in the first case considered a public nuisance? And if I can figure out how to go backwards on my screen, I'll tell you why. Let's see. Ha, there we go. And that is because, look down under the appellate decision, the Napa County Code provides it is unlawful and a public nuisance to erect or construct any building, etc., in the unincorporated territory of Napa County. So it was a specific ordinance at the local level that made that a public nuisance. I'm not sure how common that is, but that was really a triggering fact in the Wang versus Paletta case.
Dale?
Yeah, go ahead.
I think carrying that out further, it was the fact that they erected a block wall in Napa County without getting a permit. So if they had applied for a permit with it, then it wouldn't have been a nuisance. It's that it's that in this case, Wang, but either, whether it was Wang or Paletta, you can't erect a building without getting a permit, and doing so constitutes a public nuisance. So, you know, uh,
So
you know,
even more backup, right? Yeah, okay. Excellent. So thank you, Bernard. Thank you, anonymous attendee, for contributing to us. And please, if anybody else has a question or a comment as we go along, I invite you to do so. I will be looking at those from time to time. Steve, let's
uh-oh.
make this a short interview with you, Steve, because I think both of you have things to say about our next two cases, and we want to make sure we have time for them. So this is Stephen A. Sokol. Doesn't he look, very sophisticated there, beardless in his picture. I don't know. I probably grabbed it off of LinkedIn, I'm guessing. I'm not really sure. A little bit fuzzy there. I think, Steve, you look a lot better, with your head there and your shoulders appearing on our screen today. But Steve, you are a professional law corporation. You have your own law practice. So I mentioned you used to work with me, or I worked for you because you were my boss. So you left the semi-private, non-public, nonprofit center to go into business. Well, not, I think initially you had a partner, but I think you've been on your own for some time. Tell us what you do and why you do it.
So I'm a real estate and transactional lawyer. Real estate, I figured that I had been walking on land my entire life, so it was the natural thing to do. Uh, and and I like the weeds frequently that go into transactional stuff, compliance. So uh, I'm a transactional lawyer, and I do estate planning, and I do live in Calabasas, lovely Calabasas. And I was with CAR for a long, long time. I think like 16 years or something like that. And decided I would check out the private sector, and I'm good with that.
And you're good with that. Well, Steve, I'll tell you, you're just a baby for some of the people who are at CAR now. I just noticed at one of our last month's meeting, there was a listing, and two employees at Sierra have been there 40 years. We're there 40 years this year. And I'm fast approaching. So we'll see with me what happens first. Am I gonna retire, or am I gonna hit that 40? I don't know. You get like that an extra week vacation time. So maybe that's the incentive for me to stay around for a few more years. We'll see. We'll see what happens. Steve, tell me, I said originally I think you had a partner, but you've been on your own for some time.
Yeah.
Uh, did you find, what are the advantages or disadvantages of both situations?
I can be right 100% of the time if I have a partner. Actually, it was just a better model for me to be on my own, and I am, and I do consulting and an occasional piece of expert work and such, and it was just a better model for me. Uh, and they're fine, and I'm fine, and we're all good. And Calabasas has room for more than one law firm, so it's good.
Okay. And I'm gonna bring Ashley into this in just a moment, because now you've mentioned a couple times you're in Calabasas, so you're in the general LA area. Is your business practice local, or do you have clients statewide, or maybe even regionally, beyond the
Well,
state? I don't know.
it varies, but I mean, obviously now with communications the way it is, people can be anywhere. Most people that I deal with are in the uh, Southern California area, Greater Los Angeles, particularly if it's a title kind of issue, or a easement, or some kind of a uh, local governmental involvement of some sort. Generally, that's going to be, in my case, in the Greater Los Angeles area, which is number of, I mean, it's really like 5 counties. Uh, but sometimes I get a call from very, very out of the way places, other places in the country, and that's fine as well.
And
So
Steve, I'm sorry at the beginning you were talking about your practice. Do you do any litigation? Or are you only transactional?
now I'm only transactional with the exception of probate work, which is technically in the courthouse, which is my observation. I was in the LA Superior Court a week ago on a probate matter, walking the halls, and it's a sad place. It occurred to me that the lawyers are the most upbeat of the people, but everybody else hanging out in courthouses tend to be uh, less than robustly pleased with their day, you know. But yeah, that's a long way of
Okay.
saying I now don't do litigation with the
Okay.
exception of probate work.
So probate work was something you used to do, Ashley. Are you still doing that?
No, so I've stopped doing, I have one probate case that's still lingering, but I've stopped doing the probates just because now I've relocated and I'm in Austin, Texas, even though my practice is still in San Diego and I'm still licensed in California. So I've stopped doing the probates, but I do all the real property transactions, pretty heavily all throughout California, but more primarily Southern California, I'd say, is where most of my clients are from.
Yeah, I guess it would be hard for you to walk the halls of the local probate court,
I mean,
like Steve.
everything's virtual now, so I mean, you can appear, telecourt and all that stuff, at least in San Diego for sure. But just with court, if you have to make an appearance or do something, then it's just, yeah, I don't want to have that stress. So,
Okay, so I have a personal curiosity question for you, Ashley. Sorry, we don't have your contact information up, but you're welcome to share it in just a moment. And that is, now that you've been in Texas for a couple of years now, correct?
yeah, 3 years now.
Yeah, had 3 years. Okay. So have you decided to get licensed in Texas? I don't know what their rules are in Texas.
Yes, so I did get licensed here last year, and it was great because I had been in practice long enough that in Texas I could waive the bar requirement and just submit the application, the your background checks, and then you have to do this online course and test for Texas law. So it was a much easier process to get licensed in Texas, having been in practice for so many years.
Are there any apprenticeship requirements in Texas, or you could just, as soon as you get permission, you're on your own, and you're good to go on your own?
Yep, absolutely.
Okay. Well, great. Well, Ashley, we have Steve's number up there, but why don't you tell us, if you want anybody to contact you, how could they contact you if they want to?
Yeah, yeah, sure. My physical office is still in San Diego. You can look me up on my website, which is ashleypetersonlaw.com. So Peterson is my maiden name, so all my office stuff is still under that. So my phone number is 619-222-7300. So yeah, you can contact me through my website or email me. I can provide that in the link as well. But yeah, I'm like
Okay.
Stephen, I only do transactional real estate work. I don't do any litigation. So, but I've been doing a lot of heavily residential purchases and sales, and a lot of commercial leases lately. So those have been popping up.
Okay. So Ashley, yeah, please put into the chat. Like, I'm sorry, I'm laughing at something Glenn wrote into the Q&A. So thank you, Glenn, for participating. So Ashley, why don't you repeat your number one more time, and maybe then you could put it in the chat so people, and your email address so people can contact you there as well.
Yep, it's 619-222-7300. And my website is ashleypetersonlaw.com, and that's Peterson.
So perfect. Thank you, Ashley. Thank you, Steve. And let's move on to some not directly, but maybe indirectly real estate related cases. Here we go. Thomas versus Corbin Restaurant. So fascinating case here, right? Like it says right here on your screen, first impression in California. What happens if there is an intercepted email after a settlement agreement has been entered into, and the party who is responsible for making a payment makes a payment that goes to somebody other than the party who is supposed to receive the payment, right? So when there is an imposter causes one party to a settlement to wire settlement, the key here is that it was wired, settlement proceeds to the imposter instead of the other settling party. So you have a case. This case doesn't really discuss what happened in the background, but basically you had Thomas, who was the plaintiff here, sued the Corbin restaurant and its employees for injuries, right? So I don't know. There was an altercation, there was a fight, there was something, probably at the restaurant. After mediation, the parties settled, decent settlement amount, $475,000. There was an instruction that the settlement was to go to, a check was to be sent to or made out to the client trust account for the benefit of the plaintiff, Brian Thomas. Plaintiff's counsel, office administrator through the office administrator, sent the signed settlement to the defense counsel via email. Lo and behold, that started a lot of bad things that were happening. Somehow there was triggered a spoofed email that supposedly came from the office administrator to defense counsel that says, oh, let's not worry about a check. Why don't you just wire the funds instead of sending a check? And then you could, if you want to read through this, you'll see, oh, well, guess what? The fake email, the signature block had some information that was not correct, an incorrect phone number and fax numbers. The email address of the administrator was different. I have to tell you, I was reading this case. I knew there was something wrong, and I still missed it. When I was looking for the error in the email address, and there actually were two errors. I only caught one of the errors when I was looking through. It's like, oh my goodness, and if you're not looking for it, it would be real easy to miss it. There were some additional communications. Eventually, what happened? The wire went to the imposter's account. The imposter, these people are very creative, sent some information to the plaintiff, so the plaintiff was not aware that the wire actually took place. So it was actually delaying the plaintiff to contact the defense counsel to say, hey, where's the money? Right? So these fraudsters were playing it on both ends. Eventually the problem was discovered. Plaintiff moved to confirm the settlement, saying, hey, I never got my $475,000. Trial court said, well, this is unique. We got to figure out what to do with cyber fraud. Who's gonna bear that responsibility? And the court said, you know what, there were red flags that really made the defendant more likely than the plaintiff to be in a position to prevent the fraud. The defendants appealed. And the court said, yeah, there's nothing in California, so let's look at some federal decisions on this case, to something that was called the imposter rule. New to me what the imposter rule was, but who should bear the risk of a fraudulently induced wire transfer? And Ashley will discuss, hopefully, this happens a lot in real estate, in closings. We see this, unfortunately, more than we should. And basically said, well, the party who's in the best position to prevent the fraud is the one who's going to bear the burden. And kind of an interesting, anecdote here, that the court was pointing out, that fraudulent schemes may involve sophisticated encryptions, digital safeguards, and sometimes the old-fashioned ways are the best. picking up the phone and calling somebody or actually meeting them. So that's all I want to say about this. Ashley, why don't you start us off? What do you think about this case and maybe its implications beyond this situation?
Yeah, I mean, it's so sad when these types of things happen. I mean, you hear about stories of people losing their entire savings, on residential property sales where they, wire the money to a fraudulent email that escrow was intercepted by. So this is certainly something that comes up a lot in, I'm sure, Stephen, in your practice and mine, where you hear about these stories of just these fraudsters getting very creative on what they're doing to try to steal the money from these people on these transactions. I mean, escrow now, the ones that I work with at least, all use very secure encrypted emails to send the wire instructions. I tell my clients to call escrow directly, and talk with the person who is the person that you're supposed to be talking to on the phone before you wire any money. So anytime I send anything about bank accounts or wire information or anything private for clients, I send it all encrypted or in my secure portals for clients as well. So you really have to take those extra steps to be careful and advise clients to do the same.
And Steve, your thoughts.
So, as Neil said, this was a case of first impression in California, but there's a fair amount of case law that the court cited or the parties cited, and it's in the opinion from other states and federal cases. So California, the Court of Appeal relied on Uniform Commercial Code Section 3404, which has in it a rule about how to deal with imposter transactions where somebody that shouldn't have gotten money or maybe the subject of the transaction did and kind of grafted that in as a way of getting to some answer on this. But the real case, the real analysis in the opinion was that the party who was in a better position to discover that there was a fraud going on, that's who should get stuck with the problem. And the party that they picked on, so to speak, for who should have figured this out or was in a better position to figure it out was the plaintiff's law firm, because the plaintiff's law firm, ultimately, they relied on a fake email which had contact information very similar to what the true contact information was for the plaintiff's law firm, but not, somebody clever did this, and the defense law firm wired the money to the wrong place. What else I would note, and Ashley mentioned escrow and the significance of all this in escrow. I mean, of people figuring out creative ways of separating other people from their money. In my experience, an escrow officer, if this settlement had been handled by an escrow officers are pretty good about making sure that something's going to the right place, even by simply calling the law firm or whoever the money's supposed to be sent to, and making sure you speak to a human, and that you're sending the money to the right place, and nobody fake is involved. But they didn't. Nobody did that. Presumably they will the next time.
Well, with the amount of money in question, you'd think one simple phone call would be something that they would do, but people get lazy.
Almost $500,000, which is
Yeah.
not that's a significant chunk of money. So
Yeah.
So for those of you who are looking at the Q&A tab, we have a comment, really just a commentary from Glenn. And Glenn mentions that his office, we're talking about $500,000 here. Glenn's office was involved in a situation. I have no idea how you're involved. I don't want to know how you were involved. Glenn, in that situation, um, that involved $3.5 million. And from the last line in Glenn's comment, it looks like recovery is unlikely. And that's, it's really too bad in situations like that. Ashley, I love the fact that you were giving recommendations, using encryptions, making the call. I know I recently bought my mother's property in another state. I was so careful about this. I'm not even talking about anywhere near the amount of funds here, but I'm probably not in a position where I could take that kind of loss regardless of what it was. And yeah, I was extremely careful about that. Actually, now my mother sends me text whenever she gets something suspicious, right? So my mother, as she's elderly, she's 90 years old. A lot of people prey on the elderly, and she always sends me something to make sure that she's not clicking on a bad link or giving information that should not be that should not be revealed. So, take care of your parents, all of you out there. Make sure. So, thank you,
I love
Steve.
Glenn's
Thank you.
comment that Steve's picture looked like Phil Collins.
Yes,
Steve, you just
that
needed
too.
the little headset thing on the side of your photo. You'd truly be Phil Collins.
So next time I'll try to Photoshop that in.
Yeah,
Ashley commented, for those who have been around a long time, I used to Photoshop fun stuff with Ashley all the time. I just didn't have the ability to do it this time.
so
I
sad,
see
so
there's the,
disappointed. And Barry,
oh,
your comment saying, yes, you noticed the Lady Bird Lake and Colorado River in my background. That's correct. Good eye. And yes, MPRE is required for admission to the Texas Bar for out-of-state attorneys. If you score an 85 or higher on the California MPRE, you don't have to take it in Texas. So that's why I didn't have to take that in Texas.
all right, good to know. So let's go on to our last case. Getzel versus State Bar. Interesting situation here. Getzel is a longtime attorney. We've had many mediators on our program here. Getzel was a mediator and an arbitrator, and he wanted to continue doing this. He went inactive, somehow found out about Rule 2.30 Subdivision B from the State Bar and realized, oh, that's going to be a problem for me. If I am inactive, I may not be able to be a mediator or an arbitrator in California. And Getzel said, well, that's not fair. Anybody else could be a mediator or an arbitrator. Why can I not be a mediator or arbitrator just because I happen to be licensed by the State Bar? And I don't want to pay those dues anymore because I'm not actively practicing law anymore. So he brought a claim basically to say that that rule should not apply, and it's unconstitutional. Trial court sustained the State Bar's demur. Getzel appealed his equal protection challenge. He said, well, it should be strict scrutiny because it's ability to contract. The court looked at it and says, no, it's really rational basis scrutiny here. I have in the second to last paragraph what that State Bar rule, at least the way it was written at the time this case was, or at the time it applied to this case. And you sort of look in the middle of that long paragraph. No licensee occupying a position wherein he or she is called upon in any capacity to give legal advice or counsel, all right, or examine the law or pass upon the legal effect of any act, document, or law shall be enrolled as an inactive licensee. So that's really the crux here. I'm going to let the two of you go on. I just found something that I thought was a little bit. I'm trying to think. I'm not seeing the whole thing on my screen, but I'll try and find my whole quote later on and send it to you about my favorite line in this case. But Steve, why don't you start here? Tell us what you think about Getzel, and I know you learned some interesting information. We have about 6 minutes to go.
So I looked up Mr. Getzel. He has a unblemished record. Most lawsuits involving lawyers and the State Bar involve discipline imposed by the State Bar. That's not at all the case in this. Getzel was almost 49 years has been licensed. as an active lawyer, and 3 months of that was as an inactive lawyer because he thought he was going to just do mediations and arbitrations. That rule of the state bar rules says what it says, and Getzel challenged it. What I would observe is it's an odd result that a person licensed as an inactive lawyer cannot do arbitrations or mediations, but somebody sitting in state prison for felonies is not precluded from doing mediations. Somebody who's never been any licensee at all, real estate brokers and agents can be mediators and arbitrators. This is just the way it goes together. It's probably the right result, but it's just an odd result that Mr. Getzel's cannot, because he has an inactive license. He could resign from the state bar since he's not practicing actively anymore, or didn't want to, and then he wouldn't even be an inactive licensee. Then he could do arbitrations and mediations. But obviously, it's hard enough to get licensed as an attorney. People don't want to give up the possibility of going back into active practice if he wants to. So sorry, Mr. Getzels. It's a very strange result, but that's showbiz, as they say.
Ashley, your points here.
The state bar wants their money, so they're gonna find any result that will be beneficial for them. And those dues are not getting lower, that's for sure. So yeah, I feel bad for Getzel, but I agree with Stephen that I think it was the right decision just based on the fact that he does have to interpret the law as a mediator and arbitrator, and you want to have someone that's up to date on the current laws that are going to be deciding your cases. So yeah.
So John makes a comment. Well, can people who've never been a lawyer be an arbitrator or a mediator? And the answer to that, of course, is yes. The special circumstance here is that the state bar feels they need the money in their position of regulating licensees. They don't just regulate active licensees, they regulate all licensees, whether they are active or inactive. And so that was a turning point here. I raise a quick question. Maybe the two of you can give me a real brief answer, which is, do you think the same circumstance would apply if Getzel was an accountant or had a CPA, right? And then said, yeah, I'm not practicing law anymore, I'm just going to do CPA work, or was a real estate licensee, right, who are looking at contracts all the time. Do you think the same result would be? Do you think there would be the same result?
I think the result would not be the same, because this is really the result of how a particular rule is worded, and that rule only applies to inactive licensees. Inactive lawyer licensees. That rule doesn't apply to anybody else. Also, I would note there's an
Okay,
exception.
Steve, I'm going to stop you. I'm going to stop you. So let's say Getzel is an inactive licensee and also has his CPA. Says, I'm not going to practice law anymore. I'm just going to be giving accounting advice to my client. Do you think he would, and he went inactive at the bar, do you think the same result would happen here? The bar would say, no, you cannot do that as an inactive attorney licensee.
In doing arbitrations and mediations?
No, in being a CPA.
Well, no, I don't. What CPAs do isn't what lawyers do, dissecting laws and representing parties or making decisions. I don't think, if I'm understanding what you're asking there, I don't think it would apply to any other profession, like a CPA or doctors or plumbers or whatever. They have whatever regulatory system they have in place for each of those kinds of things. For can a retired doctor teach medicine, or something like that? Probably, but
all right, so I'm going to go to Ashley. I'm going to make my last comment, and we're going to do our what's up with us, let you know what's going on with us.
Yeah, I agree. I don't think the result would be the same if he was saying, I'm doing CPA work that's not related to the law practice of law. So,
Okay. Well, the reason I asked the question was I was looking at the phrase, or pass upon the legal effect of any act, document, or law. So is there a legal effect in saying you can take a deduction? Is there a legal effect of the real estate licensee saying, well, maybe this contract is enforceable or this addendum is or is not? I hope there would not be the same result, right? Because it's not really the same as a arbitrator who is certainly passing judgment or a mediator who's using that judgment to try to get the parties to reach a settlement. But I just raise that as an issue because why not create some problems before we leave today? And to see if I can go to our last screen here. Oh, there you go. So you can see my favorite line was uh, the court kind of took a stab at Getzel for, you know, as an inactive licensee who was citing to overruled and repudiated case law. I just thought that was kind of interesting. So what do we have going on at the real property law section? First of all, thank all of you who joined us today. I really appreciate that. Hopefully, this is just one activity that you find interesting and valuable from the real property law section. Um, we've got coming out soon, we've got a new issue of the Real Property Law Journal. And actually, very soon after that, there's going to be a second one. There was some kind of a delay that's been resolved now. We have a monthly newsletter. It's called the e-news. You don't have to write a 25-page law review type article. You can write a one-page summary of something that you've seen in your practice that you think is interesting to anybody, who's practicing real estate law. Gave you examples of a couple of articles that have been written the last month. We've got, I think, 8 or 9 different practice area or subcommittees. So you can contact Jose if you're interested in learning about those. Bunch of webinars coming up the rest of the year. Well, we just missed the one in Dubai, but you can catch it in the CLA library. Maybe that's what our winner Bruce Boyd will do with his gift card. How do you end construction contracts coming up in September? Dealing with wildfires, still a big issue coming up in October. Legal ethics in a remote world. I kind of like that one coming up in November. And overlooked lease terms coming up in December. You can see the events we want to let you know about. The CLA annual meeting, the buying a home in California for junior lawyers is kind of a repeat of something we did about a decade ago. It's basically how to buy a home without breaking a bank, without breaking the bank, and can you do it as a junior lawyer in California? Will your junior lawyer's salary enable you to buy a home in California? That's going to be in San Diego in November with myself, with a real estate practitioner, and we're also hoping to have a lender or loan broker there. So interesting thing. And next year, we're going to be in Yosemite for the annual RPLS retreat. So a lot of good stuff next month. I know I saved up a few landlord tenant cases because Michael is really into those. We'll see if we can get through more than 2 of them because Michael likes to talk about that kind of stuff. So we'll see if we can get through 3 or 4 cases next month, but good stuff. I hope you join us. A special thanks to bringing back Ashley Peterson Hull. Thank you for joining us, Ashley. And let's see, Ashley, I didn't see you put in the chat how to contact you, but
no.
why don't you say that one more time? I don't see it in the chat.
Is it in the chat? I thought I did type it in there. Oh, sorry, I sent it to Brooke directly. My problem. That's my problem. Okay.
Tell you what, Ashley, we'll include a special note when we send out the information to everybody. When you get the information no later than Monday, you can see how to contact Steve. All right, Steve, Ashley, each of you have 10 seconds to say goodbye.
Thanks, Neil. It's so nice to see you. And Steve, it's great to meet you. And I appreciate the opportunity to come back.
Of
For
course.
attending, and thanks for the invitation, Neil. Appreciate it.
Thank you, everybody. Hope to see you next month. Bye.